Hi everybody, this is Brooks Lindsay, the founder of Debatepedia.org. I just went over the pro-arguments in favor of the Supreme Court's ruling on Citizens United. This was January 21st, 2010. This was Citizens United versus the Federal Election Commission. And the Supreme Court ruled in favor of Citizens United, and more broadly speaking, in favor of unlimited spending on campaign ads and other kind of campaign materials in elections. So this is particularly of concern to critics in regards to corporate spending on these campaign ads. And I just wanted to go over quickly some of the con arguments against it, having already gone over the main arguments for it. So one of the arguments that can be found on Debatepedia's article on the topic, which you can find on the main page, www.debatepedia.org, is the right to free speech does not apply to corporations. So one of the main conclusions of the Supreme Court's decision was that the right to free speech applies to corporations as well as to individuals, and more generally, that all rights that individuals have, corporations also have. In other words, corporate personhood. That's the argument that the conservative majority ruled in favor of. The case against this I'm going to kind of outline right here. And here's a good quote on, again, the argument, the right to free speech does not apply to corporations. So the article is, "Court's Blow to Democracy," and this is the New York Times main editorial on the topic, and this was actually January 21st, 2010. So the quote is, "The founders of this nation warned about the dangers of corporate influence. The Constitution they wrote mentions many things and assigns them rights and protections, the people, militias, the press, religions, but it does not mention corporations. Most wrong-headed of all in the Supreme Court's 2010 decision is its insistence that corporations are just like people and entitled to the same First Amendment rights. It is an odd claim, since companies are creations of the state that exist to make money. They are given special privileges, including different tax rates, to do just that. It was a fundamental misreading of the Constitution to say that these artificial legal constructs have the same right to spend money on politics as ordinary Americans have to speak out in support of a candidate." This quotation is probably the crux of the case against the ruling. And just to emphasize this again, the main idea here is that essentially corporations are state legally created institutions. In other words, they only exist because the state creates laws that say that they can exist. So this is distinct from an individual. Let me just back up real quick. So their rights, a company's rights, are given to them by the state, whereas an individual's rights, as we see it in the Constitution, are God-given. They're God-given. But a company's rights are not God-given. They're given to them by the state. Huge distinction, very important distinction, and one that the Supreme Court's ruling seems not to see. And so they give corporations all of the same rights as an individual would have, including the right to free speech. And this is why they then conclude that it's justified to allow a company to spend unlimitedly because they argue, have this right to free speech. So I'm going to go down the list even farther on the case against. Here's one argument. Corporations do not have rights like individuals. So this is what I just went over, but I'll read a quote here. This is from Lisa Gilbert, and the article is "In the Public Interest, Corporate Democracy, the Citizens United Opinion, Huffington Post, June 21st, 2010. The corporation is not, nor has it ever been, a person with voting rights. Corporations cannot get married, they cannot die, and a corporation is not a part of we the people. The very idea that they can now channel their immense wealth to advocate directly for or against a federal candidate is abhorrent." So just kind of driving that point home. Another argument is corporate spending doesn't count as speech. So I think this is actually a relatively interesting point, in that the idea of speech as it's defined in the Constitution and defended in the Constitution is, an individual can speak out, a corporation can maybe speak out, or an advocacy group can maybe speak out, and that's defended. that right to speech on a certain level. But the right to spend unlimitedly to propagate that speech is not defended in the Constitution. The right to speak on some level is defended, but the right to spend unlimitedly to advertise, propagate that speech is not protected. And I think this is a pretty serious blow to the case that the Supreme Court has been making as well. But again, a pretty fine distinction between spending and speech. Spending limits, another argument, spending limits protect voter voices from being priced out. So I'll just read this quote because I think it really, this is from Debatepedia's article, defines it very well. Karen Finney, Democratic consultant and commentator, former spokesman for the Democratic National Committee, wrote in a January 24, 2010 Washington Post piece, in a decision that supposedly ruled on the side of free speech, the court actually put a price tag on that speech, a price tag that could result in the voices of individual Americans being priced out of their ability to actually be heard, as millions of dollars from multinational corporations can now be spent to tip the scales in an American election. So this is, I think, a really interesting argument because it's not just speech that we're talking about, it's your message, your speech getting across to voters, influencing voters. So obviously an individual has the right to speak, but they don't have all that much money necessarily. The average individual doesn't, as compared to a corporation that might have vast amounts of money that can spend behind its message to price out individuals who are trying to voice themselves. And so the issue here, of course, is that if individuals have a right to free speech, and yet they are being totally drowned out by corporate spending and propagation of corporate speech, then their right to free speech to some extent is infringed for sure. Another one I'll go over is unlimited corporate spending will kill small donor candidates. So there's a good quote here again. Greg Palast, this is from the article Manchurian Candidates, Op-Ed News, January 23, 2010, quote, candidate Barack Obama was one sharp speaker, but he would not have been heard and certainly would not have won without the astonishing outpouring of donations from 2 million Americans. It was an unprecedented uprising by PayPal, overwhelming the old fat cat sources of funding. Or kiss that small donor revolution goodbye. Under the court's new rules, progressive listservs won't stand a chance against the resources of new citizens such as CNOOC. New, quote, citizens, mockingly, sarcastically, such as CNOOC, the China National Offshore Oil Corporation, and other companies. So the point here is that the small donor-based campaigns that have been run, like Barack Obama's campaign, where the people's voice was heard, I guess you could say, or the individuals' voices collectively were heard, you know, and this isn't just Barack Obama, it could be a Republican candidate as well. You know, let's talk Scott Brown. Those individual donorships, those kinds of campaigns, they are going to be much more unlikely now that unlimited spending is legal. And the reason is that most candidates now are going to be raising substantial amounts of money just through a couple of corporate sponsors. They're not going to need as much to go to, you know, the individual donor. So again, this is a way in which the individual, the citizen's voice collectively is going to be kind of priced out and drowned out. So that pretty much covers it for the free speech section of our article on Debatepedia, and there are about 7 more sections. I'm just going to go over one that's also related to free speech, which is this question of associations and the right of association, the right to free speech in the context of the right of free association. So what the conservatives have said is that spending limits infringe free speech and associations. So Justice Antonin Scalia stated that Justice John Paul Stevens' dissent against the Citizens United ruling was, quote, in splendid isolation from the text of the First Amendment. Never shows why, quote, the freedom of speech that was the right of Englishmen did not include the freedom to speak in association with other individuals, including association in the corporate form. Now, the main argument against this, I think, is pretty potent,